Tracey Davillier, the Chief Judge of Criminal District Court for the Parish of Orleans. The Honorable Rhonda Goode-Douglas, who is a judge in Criminal District Court as well. And then the Honorable LaKeisha Jefferson, who is a judge in Civil District Court. I have two here. Have you want to sit? Have you want to sit?
She said a fourth lady in there. What a fourth?
And judges, thank you again for being here and taking time out of your schedule. But I can say that I see this group of judges, like all of our city, serving our city. I just wanted you all to share what you see in court, what you see, and just to let the community know the work that you guys are doing in your respective courts as it relates to domestic violence. Thank you.
All right. Good morning, everyone. Again, I am Tracey Davillier. I am Chief Judge of Criminal District Court and work very closely with the Family Justice Center. So I applaud you all and all of your efforts, everything that you do in Criminal District Court. So with domestic violence, Criminal District Court has tried to take a very unique, approach to domestic violence. I currently serve on the City of New Orleans' advisory group for domestic violence, where we meet quarterly to talk about domestic violence issues and to make sure that processes and systems are in place that are actually working for the survivors, working for those who are being victimized, and working for the various court systems. And we have everyone on that advisory board from 911 Communications District, EMS, we have police department representatives from advocacy groups like the Family Justice Center, Criminal District Court, Civil District Court, probation and parole. And so we have a myriad of people who are all adding information and their perspectives with respect to domestic violence. Criminal District Court has a unique domestic violence monitoring court program. And so immediately upon arrest of anyone who is arrested on a domestic violence issue or domestic violence case, and I see our lead director of our domestic violence monitoring court, Barbette Sneed, and she does a great job leading all of our case managers. Thank you very much for being here. And so immediately when someone is arrested, they are automatically assigned to a case manager. They then have to, if they post bond, they have to check in with that case manager regularly. They have to drug test, and there are other conditions that may be placed. We also place on that person an electronic monitor. So if bond is posted, they are automatically placed on an electronic monitor. The alleged victim in the case has a right to receive a key fob. So then that key fob creates basically a restrictive or prohibited zone so that the accused party cannot go within a certain perimeter of the alleged victim at that time. A protective order is automatically issued. And so in criminal cases, unlike civil cases, it's very different. Once a person is charged with a domestic offense, a protective order is automatically issued. It's issued for the alleged victim, it can be issued for children, it can be issued for family members, etc. In addition to that, we have our firearms declaration, which is another subcommittee where if anyone declares, and it happens, sometimes they will actually tell the truth and declare that they have a firearm, they are required by law to turn over that firearm to the sheriff's office. And so we have a number of systems that are in place immediately upon arrest. And our commissioners and our magistrate court judge are very well aware. They enforce those requirements. We also have Gwen's Law hearings. Gwen's Law hearings are if a person is perceived as a danger, an ongoing threat, ongoing danger to the alleged victim and their family or anyone else, then that person can be held without bond. And we've held a number of people without bond, and we still do. If the district attorney's office, after reviewing a case, decides to accept the case and file formal charges, then the case managers under Ms. Sneed continue to monitor that person, and that case is assigned to a section court. So from magistrate court, they didn't then go to a section court. Judge Goode-Douglas and I are judges presiding over the section courts. We have 12 section courts. A through L. And so the case is assigned to any one of those sections, and the case managers continue to monitor those parties, and they continue to let us know if there's any non-compliance. The electronic monitoring companies will communicate with the case managers to let us know if someone is violating their terms of electronic monitoring. From there, if a person is either found guilty or pleads guilty, then they are then still required to participate in the domestic violence monitoring court. But there's an added condition that they take batters intervention classes, 26 batters intervention classes, and it's basically behavior modification. That's for those that are placed on probation. If they're not placed on probation, then obviously they're incarcerated. And so we have a lot of different things that we have tried to put in place through our unique domestic violence monitoring court in criminal district court. I was lucky enough to be a part of the Blueprint for Safety Development with the City of New Orleans in 2014, where we basically developed a set of procedures, policies and procedures to address domestic violence across the board, from the first 911 call to the police going out to the scene, to the district attorney's office, getting the cases, going to magistrate court, bond conditions that are set, to the formal bill being filed, a formal petition being filed, to the time when they come to us in section court, through conviction, through probation, etc. And so we monitor those cases and we take them very seriously. And just the last thing I'll emphasize before I turn it over to my colleagues is that in criminal district court, understand that protective orders are automatic. We know that there's a different procedure for civil district court, and we know that that's very sort of a more intricate system that requires additional hearings. Protective orders are automatic in criminal district court. And so that's the beauty, sort of, for lack of a better way to say it, is that it's automatically imposed, period. And they must be abided by. And this is before there's an informal petition involved. And so there's immediate protection that is in store for that person, in store for that alleged victim. And so we're pretty proud of the program that we run in criminal district court. I think because of our wonderful case managers, we have 6 total. They help to decrease the recidivism rate with the intense monitoring and supervision that we do with respect to those perpetrators.
So I am Judge LaKeisha Jefferson. I serve in one of the dedicated family court seats in Civil District Court. Prior to being elected judge, I actually used to work at the Family Justice Center with Mary Claire and Misty. I actually also used to be a contract attorney for Project SAVE while I was in private practice, and then before that, I was an assistant city attorney and I prosecuted domestic violence cases. So bringing that experience to the bench is very different because, as Judge Fleming's Davillier said, our process in Civil District Court is very different. There has to be a petition filed first, and once we get the petition, as the family court judge looking at that petition, we can only make a decision based upon what you've written down. So that's where the work at the Family Justice Center becomes very important, because they have trained advocates there that will assist them with filling out and completing the paperwork. They know what we need. So I use that as an example because when you come into Civil District Court, you're gonna first be met on the first floor at the help desk. There may or may not be someone there because the help desk is only staffed by Pro Bono Project on Mondays, Wednesdays, and Fridays. I say this like a million times a week, but Monday, Wednesday, and Fridays, 9 to 12. Those are the only hours that they're staffed. If you come into Civil District Court at one of those times outside of those hours, you're going to be completing the paperwork for the petition by yourself. You're not a lawyer, so that can be very difficult. And then if you're not putting enough information into the petition to let the court know why a temporary restraining order should be granted, then it is likely to be denied, because on the face of the petition, it may not have everything that we need to see to determine whether or not a TRO should be granted. So I'm just gonna be honest with you. If you give me one sentence and it comes to me, it's probably not going to be granted, because that's not giving me enough information for me to determine whether or not there's physical abuse, sexual abuse, or anything defined as a crime under the criminal code in order for me to grant that temporary restraining order. So that's why that's very different than the process in criminal district court, because they're giving immediate stay-away orders in connection with the charge that the defendant is facing. So that's a different process. But in our process, once you file your petition, if we grant or deny the restraining or the temporary restraining order, you're gonna get a hearing date anyway to come back before the court to present your case at the protective order hearing. The other drawback to that is that if you don't give me enough information in the petition and I have to deny the temporary restraining order, you're bound by whatever you put in that petition. So if you want to tell me, well, Judge, there's all these incidents that occurred in 2014, all of these incidents that occurred in 2015, but if you only wrote the one incident that occurred on August 15, 2025, if that's the petition that the defendant got served with, I can't let you tell me about all the other stuff because you didn't put it in your petition. So if you're coming into civil district court and let's say you didn't go and get the assistance of the Family Justice Center, or you didn't go and get assigned to Project Save to get an attorney there and you're filling it out for yourself, I want you to tell everyone that is filing a petition, put more information than you think you may need, because that helps us to make a better determination of whether or not to grant the temporary restraining order on its face.
All right, good afternoon, everyone. I am Rhonda Goode-Douglas. I preside in Section E of the Criminal District Court. And so my experience was, I was a prosecutor for about 12 and a half years in Orleans Parish. I prosecuted for 2.5 years in Jefferson Parish. When the Family Justice Center first came to New Orleans, there was an agreement with the District Attorney's Office and the Family Justice Center to have assistant district attorneys actually work in that office. I think it was about 6 of us at the time. And so I was one of the first prosecutors that was assigned to the Family Justice Center. Actually, we were on Julia Street at that time. And we were a one-stop shop. Whenever survivors would come to the Family Justice Center, if they needed to speak to the assistant district attorneys, we were right there. At some point in time, I believe now there may be 1 or 2 assistant district attorneys that are there, but at that time we had a really robust staff, and so I screened and prosecuted domestic cases for a very long time, domestic homicides, domestic, just regular run-of-the-mill domestic cases as well. So now, what happens in criminal district court when someone is actually charged and convicted of domestic abuse battery? So as Judge Fleming's Davillier indicated to you, we do have a very robust pretrial domestic monitoring service. We also have domestic violence post-conviction court. I am one of the judges that monitors that court. And so right now I have probably about 60 to 65 defendants who are currently on probation. And so in order to qualify for that court, number one, you have to, the state has to agree that this person should not go to the Department of Corrections. Whatever their criminal history is, they are qualified and can be on probation. So that's the first step. Then the second step is that they qualify for domestic monitoring court post-conviction. And so what happens is generally they are placed on probation for 2 to 3 years and they must successfully complete our program. As Mary Claire said, we certainly need to start thinking of innovative ways to treat offenders. And as Mary Claire said, accountability when you are in my post-conviction domestic abuse court is key. I find that we have substance abuse issues with a lot of the offenders, and so we're treating that. They must drug test on a regular basis. They drug test as much as the defendants that are in drug court. If there is a substance abuse issue, we are going to treat that. You are not going to progress through that program until we are successfully treating whatever problems you have. If there is some sort of therapy that is needed. We are trying to get as much resources to control recidivism as possible. I do have some that will come back and then ultimately their probation is revoked and they're going to the Department of Corrections. But we have seen some success with some of the individuals that have come through the program. And so it allows the court to monitor that person when they are on probation. Because we do have many people that go through the probation and parole, they're never seen in court again. No one knows whether or not they've completed their classes, which is a mandatory requirement if you are on probation. And so this allows the court to sort of have a role in making sure and ensuring that, number one, those classes are done. Number two, what other issues do we see in this person's background? How can we assist so that if the survivor decides to reunify with this person afterwards, then hopefully we've treated whatever conditions or issues and hopefully make this person whole again.
So Judge, and anybody can answer this, tell me about the number of cases that you guys have seen. Like, what are the stats for civil district court and criminal district court?
So, of course, I was pulling up our stats because we do have a very good program coordinator that tracks all of our stats for all of our programs, which, as you know, is important for our grants. For domestic violence, for example, for protective orders, just this year we've issued approximately 1,953 protective orders have been issued just this year as of September 25th, which is our third quarter. In terms of Gwynn's Law hearings, we've had 241 Gwynn's Law hearings as of the end of September, which is really great. We have about 321 perpetrators on electronic monitoring at this time. In terms of the participants that we're seeing in domestic violence monitoring court, at the end of September, there were 615 participants in domestic violence monitoring court on a pre-acceptance basis. This means arrested, not yet in a formal case. And for those that are on probation, we have about 305 at the end of September. So we're seeing, and it looks like, would you agree, Judge Goode-Douglas, that each year it looks like there are more and more domestic violence cases on our docket. They may not all come through as domestic abuse battery or some type of, they may come in as home invasion, they may come in as attempted murder or some other type of more serious felony offense that comes to court, basically. And Judge Goode-Douglas, her court, I guess what is important to emphasize is that all of the judges monitor probation for those who are on domestic violence, but Judge Goode-Douglas and I work specifically, along with Judge Lombard, to address a more intensive and develop a more intensive domestic violence monitoring court for those who are assessed as high risk, high need. So what we do is basically a rating, low risk, low need. Those who are high risk, high need are intensely monitored by both Judge Goode-Douglas and Judge Lombard. So they're getting basically an extra set of eyes on those particular perpetrators.
Judge Jefferson, and I was also, when you answer that question, could you kind of explain so that the audience is clear the difference between what you do as a civil district court judge as it relates to protective orders versus criminal? Because you're here in the terms of probation and arrest, but on the civil side, we don't have the jurisdiction to do that. So just so that the audience is clear on that process.
Right. So to answer the original question of how many cases we're seeing, there are 3 domestic relations sections of civil district court. That means that we are the 3 judges who hear divorces, custody, child support, spousal support, community property divisions, and protective orders. And so there's a difference between a petition for protection from abuse and then a petition for protection for stalking. All of the 3 domestic relations sections of court get all of those petitions for protection from stalking, as well as the petitions for protection from abuse, because they're on the Louisiana Protective Order Registry form. So if you file that particular form, whether it's for abuse or whether it's stalking, it's going to come to one of those 3 divisions of court. I probably get about 10 new petitions in just my division a day. I think that it's happening also in the other 2 divisions because it's random allotment. So I think we're probably seeing per division 50 new orders per week that are getting filed. So that's 150. Now that's a mixture of stalking petitions and it's a mixture of abuse petitions, which the stalking petition is limited only to dating partners for sexual assault, and then also petitions for protection when you have stranger or acquaintance abuse, or that's the allegation for stalking. For petitions for protection from abuse, that's dating partners, that's familial relations such as grandparents, grandchildren, children and parents. In a limited number of cases, it might be sibling violence as well on the petition for protection from abuse, but we're getting roughly by all 3 divisions, roughly about 150 new orders every single week. That becomes important because of scheduling purposes. We already have the rest of the docket that we're handling, but with petitions for protection, when it's an initial petition, it has to be set within 21 days, which means that we have to find room on the docket to make sure that we're meeting that time delay. There's also a 10-day portion of that legislation that we have to be careful of when the temporary restraining order is denied. And then service sometimes becomes an issue on that original court date that you get. So if we have to reset it, we can't reset it within 21 days. It has to be set within 15 days. So what I do in my division, and I think Judge D'Souza and Judge Henry are also doing this, we're doing 2 dockets a day. So my 9:30 docket in the morning is for all of my other stuff. My 1:30 docket every single day, Monday through Thursday, is going to be protective orders only, just so that we can make sure that we're keeping up with the number of petitions that we're getting filed in our divisions. I believe Judge D'Souza does her protective order docket every morning at 9, and I think Judge Henry does a mixture. It could be any time, but we're all doing 2 dockets a day to keep up with the number of petitions that we're receiving. Answering the second question, the difference between these 2 courts, there is a difference, but it's important for us to still make sure that we're communicating. So I actually communicate with Magistrate Judge Lombard very often because we also have to make certain that we're not issuing competing orders. That becomes important because in civil court for our 3 domestic relations, we have custody issues that we also have to be mindful of. So if someone is on probation, let's say in Judge Goode-Douglas's division of court, and there's a stay away order that she has issued, but let's say in my court, we've not made it to the trial phase yet because there may be a service issue where the defendant has not been served yet. I might be dealing with a temporary restraining order. Judge Goode-Douglas is dealing with the actual stay away order that is issued for either the life of the case or for a specific period of time while they're on probation. If these 2 parties have children, it might require me to communicate with Judge Goode-Douglas because I don't want to issue a judgment on the custody, forcing the parties to exchange the child that could place the defendant in a position to possibly violate by just simply exchanging the child. So I talk to Judge Lombard very frequently about if I find out that there's a corresponding criminal case that may be going on where she sees them at the pretrial level for arraignment purposes or bond setting purposes, then I communicate with Judge Lombard to say, hey, I've got this custody judgment, this is the exchange. Tell me what the terms of your stay away order are because I want to make sure that the judgment that I issued to make them exchange is consistent with the language in the stay away order there. Because I don't want to put the victim in a situation where that victim is being possibly placed in a more dangerous position to have to meet up with the offender. and I don't want to put the offender in a position where he's violating Judge Goode-Douglas's order, and then could get the probation revoked. So it's important for the two courts to still communicate, even though we have two different sets of jurisdiction.
So I just want to say that is so important. I've had a few cases on my docket where I didn't know that there was a civil protective order. I didn't know that there was a custody order. And so sometimes a defendant may try to get me to they'll ask me, well, can I see my kids? Well, our protective orders in criminal district court will bar you from that. However, there may be a custody order that I don't know about. And so that is so important that we have all of the information and look at all of the cases as a whole. And unfortunately, our systems don't necessarily speak to one another. And so unless the court is made aware by either the survivor or the person that's charged that there are other proceedings, we don't necessarily, we sometimes will maybe put an order in place that may be more restrictive on a custodial issue, or someone may ask to do something that could possibly undo what the judges have done in civil court.
I want to add also, we have a duty judge calendar that we follow in civil district court. And so sometimes we do have people that will come in, we'll compete in protective orders. So we'll get maybe a mom might come in asking for certain protections and then asking for custody of the child. And then as the duty judge, we're looking at the facts that's been presented to us on the different documents. But then, and I've had this happen as duty judge, I've had somebody come in like on Monday and request protection and then custody of the child. And my staff, they're kind of conditioned now to know. So we ask them, is there a pending divorce? Do you guys have a pending custody order? Because people will come in, they will use protective order, ask for the immediate custody, we give the custody, and then a few days later we might get a dad who will come in, and then the dad is also asking for custody. Sometimes they may come the following week. People know our duty judge schedules, they pay attention to see who's duty judge, and they come in and file, and then, so we get that. Our sheriff's department has gone out in several cases, retrieving children from households that the children may not have should have been in. We see instances where we have school officials that are calling and trying to figure out which protective order is in place, or if they do have a protective order. And just because somebody files a protective order doesn't necessarily mean that all things in the protective order is going to be granted. We're going to look at what the request is. We're going to look at the statements that's been provided, like Judge Jefferson said. If you don't write one sentence, because if you write the one sentence, it doesn't help. I can tell you, for me, when people come in with the item number, that usually helps. If I can see, the item number, if I'm looking at the report, I've had people bring in pictures, all those things, right, to help the case. But just make sure that you have detailed information, and just be mindful that the judges are paying attention. So when we see, if we already granted mom the custody of the child, I can say I haven't just changed it 3 days later when I get a dad coming in, because I know that that person, that family, that case is going to go before Judge Jefferson or Judge Henry or Justice Souza within that 21-day period, because we're setting them. The other thing is that Louisiana Protective Order Registry, they have done a good job of making sure that judges, lawyers are aware of domestic violence and what domestic violence is. But then also with the registry, if somebody has a protective order that was issued in Lake Charles, or if they issued in Shreveport, then we are able to go into the registry and we're able to locate those protective orders, because we do have some people that form shop as well, one parish, and then I think they believe that, we're not gonna find out, so then they'll come in. And then also it's important for survivors to bring information, share information If you do have an attorney, let us know that you do have a protective order in place, you do have a custody order in place, because sometimes we'll have visitation that's supposed to happen, and then we'll get something where there's a protective order in place. So the judge may have ordered something because the child was also exposed to the violence that occurred. So just be mindful that the judges are reading the information and reviewing the information, so that we're making sure that we're doing the best job that we can for the public, but that we're also following the law. So you guys want to answer that? Because I know y'all seem like way more than I am.
To that point, that's an excellent, and I didn't even think about that till you said it. Out of parish orders or out of state orders even, the Supreme Court is actually developing an online LPOR portal so that all of the judges across the state and across the nation will have access to this online portal to determine when there are other orders that are out of parish or out of state, or even in your own parish that you may not know about. The good thing about New Orleans, we all know each other. So even before some of us got on the bench, we had relationships, or we may have come across each other in practice, so we have cell phone numbers. So it's great now that we're able to just call each other just to make sure that we're communicating. But that is an excellent resource that they're working on right now, and I think they hope to have it up and running in 2026, which will help with the ease of communication between the different tribunals.
Final thoughts? Okay. So what I will say is that obviously, domestic violence is a plague in our community. We have to come together as a community to combat what is going on. If you see something, say something. If you're given a call by the district attorney's office and they want you to be a witness to something, because unfortunately, maybe the survivor doesn't want to come in, do that. Be that protector of the person that can't necessarily speak up for herself. Those cases, a lot of times, are very complicated, very complex, and it takes all of us. It takes a village to really make sure that justice is being served. We are here in the criminal district court to serve the community, but it takes all of us to ensure that justice is brought.
I would definitely echo those sentiments. You gotta help us help you, right? I can't reiterate enough how important it is to make sure that when you're making that application in civil district court for a protective order, give too much information. I mean, because not giving enough information puts us in a situation where we may not be able to grant that order even when you come for your trial. And so it can be very frustrating to be in the middle of a hearing or at the end of a hearing and we have to dismiss it for whatever reason, and then you're thinking about all of these other things that you probably should have said. I say just start on the front end. Fill that petition up. There's more than enough room, and the clerk's office at Civil District Court has extra sheets for you to add. So you can take as much time to complete that petition. There are some people who even take the petition home because it takes quite a while to put all of that information together. And I say if you have to take it home,
go up next.
Take it home. Add all of the photos, add all of the item numbers, add all of the police reports if that's necessary. Give us as much information as possible so that we can make that decision. And then the last thing I wanted to say was that we are also, as Civil District Court judges, in a position to, even though we don't have the authority to monitor on, let's say, a probationary type of situation like what the criminal district court judges do, there are things that we can do as civil district court judges to make sure that the person is still on the right track. So we will often grant an order to the petitioner that requires the defendant to go through domestic abuse intervention programs, the same way that the criminal district court judges do. The reason that becomes important is because when you have custody that is attached to this, that defendant, once there's a protective order that's granted, before they can even ask for any form of physical custody or legal custody, they are required by the Post-Separation Family Violence Act to complete the domestic abuse intervention program. So for the protective orders that I issue, if I order the defendant to complete the domestic abuse intervention program, I always set a review date. 6 months out or either 1 year out for that defendant to have to come back before me so that I can make certain that they've completed that program. Also, the statute says that if a protective order is granted against that defendant, he or she is required to be cast with the costs associated with the filing of that petition. So I also set a review status for them to come back on a pay status so I can make sure that they paid the clerk's office back for the filing of that petition, that they paid the Project Save attorney or the Southeast Louisiana Legal Services attorney, the attorney's fees that were cast in connection with the granting of that order. It's all about compliance. On the civil side, there's just another way to ensure that there's no recidivism. If you keep kind of a short leash on them to make certain that they're still reporting back to civil district court, then that helps for them to remain compliant and not reoffend.
And then finally, just two more things to add about criminal court is, and I didn't add this earlier, but the Family Justice Center has partnered with criminal court on another sort of sub-program with the Air Advocate. And so we have Misty's here, and of course she's been leading that effort. So we will have an Air Advocate actually starting this Monday in magistrate court in the mornings throughout the entire day to work with those victims who come into criminal district court so that they can receive information, they can receive advice. It's not legal advice, but they can receive advice and information from an actual person who's well versed in what the cycle of domestic violence is and then what the process in criminal district court is, because we know that the process a lot of times is can be very intimidating because victims obviously aren't represented by an attorney. You have the DA's office, but they're basically representing the people of the city. So that's the difference. So we're proud that our Air Advocate will be starting in criminal district court, in magistrate court on Monday. And then finally, I'd like to say, I know a few of the students are still here, students that asked about what could you do to assist. And I know Judge Sheppard has probably talked about this a lot. The laws, we've talked about this as well, is that domestic abuse battery is a misdemeanor. That first offense is a misdemeanor. It's not considered that serious all of the time. So the laws are really important in terms of how serious the state legislature really views these particular offenses against people. I think the convictions, sentencing ranges for abuse of animals is higher. The sentencing ranges are more drastic for an abuse of an animal, which we love our animals, right? They're members of our family, so nothing against our dogs and cats, but that goes to show you sort of what how people in society has viewed domestic violence as a private family matter and something that they sweep under the rug for so many years. So it's getting involved in the legislature, getting involved, their city council trying to change some of those or trying to address some of those issues with the laws to tighten those laws up. And again, I think the group, the advisory group that we have with domestic violence with the city of New Orleans as well as the state has been really instrumental in tightening up a number of things with protective orders, firearms declarations, etc. But the laws really do need to be changed. They really do need to be amended. We need more women in office, more women running for these positions. That's the big picture. More women speaking about these issues. Because I think that we all understand, and it's not to say the men don't understand, because I applaud the fraternity Omega Psi Phi for being here and for always conducting this annual domestic violence monitoring seminar along with Judge Sheppard. But we do need, though they're not there, unfortunately, to propose or amend the laws. And so we need more people who are well versed on domestic violence and what the cycle is and what the consequences are to be involved in the state legislature. So that's how I will end. Thank you.
So I won't say anything further. I do echo everything that they've said, but these are my colleagues, but we also have been friends, just like Judge Jefferson said. It's important to have relationships, and they are my friends, easy to work with. I'm like, hey, this is what I have going on, but they support, and they've been supportive for years, and so we just want you guys to know that the courts are here, we're paying attention, but we do understand, and we want to make sure that we're doing our job to make sure that we're protecting the citizens that are coming through the courts. So please give them a round of applause. Thank you. Next, we're going to have our keynote speaker right after we take this picture.